Good afternoon, distinguished colleagues. And it's exactly 2 p.m. and we're about to kick off on this training. It is the second edition of the Intellectual Property Law series. You would recall that 2 years ago, we had a training on intellectual property law organized by a very astute faculty with Professor Bankole Shodipo, Mr. Femi Agaba, Simio Yelude, Ntai Etniken, Ujo Tudo and Chinasa Owana as part of that faculty. And that particular training was the first training that the Institute of Continuing Legal Education had in a very long time, and it was very well received. So thank you very much for joining again today. My name is Tobena Erojikwe. I'm the chairman of the governing board of the Institute of Continuing Legal Education. We're delighted to welcome you today for this training. We're happy to see the level of interest that this training has generated. Over 4,000 people registered to attend and counting, and we hope that indeed we have as many participants as those who registered. So now it is my pleasure to introduce today's topic. Today's topic is Towards a Stronger Intellectual Property System in Nigeria, IP Policy Emerging Legislation. And the title for today is one of the most renowned IP law practitioners in Nigeria, Professor Bankole Shodipo, Senior Advocate of Nigeria, is the senior partner at G.O. Shodipo & Co. He was called to the Nigerian bar in 1986. He received his LLM degree from the University of Lagos while in legal practice at Chief G.O. Shodipo & Co. and his PhD in law from Queen Mary and Westfield College, University of London, in 1995. He's a specialist in intellectual property, technology, communications, and allied rights, especially in dealing with regulators on a wide variety of sectors. He has been involved in litigation and mediating contentious matters and advising on non-contentious cutting-edge matters in many aspects of commercial law, in cases which have been resolved during or after trial. He has been involved in lobbying for drafting and advising on laws, regulations, and policies. He has also been involved in advising on foreign direct investments matters in various sectors of the economy for over 3 decades. This includes obtaining licenses and permits, privatizations, company reorganizations, mergers and acquisitions, antitrust and competition, corporate finance, energy regulatory, oil and gas, environment, land and resources, intellectual property finance, tax, anti-corruption, advisory and regulation, takeovers and the like in various sectors of the economy. He's a regular contributor to leading international journals. He has also worked with leading firms of solicitors and at barristers' chambers in London. He organizes and speaks at conferences in Nigeria and internationally. These include the Frankfurt Book Fair, the Copyright Society of America, the American Intellectual Property Law Association, and the University of Maastricht. He's a professor at the School of Law and Security Studies, Babcock University, where he has served as a former head of department and former dean of law. He has served as an adjunct research fellow at Queen Mary, University of London, an adjunct research fellow at the Intellectual Property Institute, Queen Mary and Westfield College, a visiting guest lecturer at the Nigerian Law School, University College London, and Pan-African University, Lagos Business School, and a consultant to the World Intellectual Property Organization. I mean, it's obvious that we have not only just an astute practitioner, but an erudite scholar as our tutor for today. And indeed, it's a pleasure and an honor once again to welcome you, Leonard Singh, Professor Bankole Shodipo. Sir, the floor is now yours.
Thank you very much, Mr. Chairman. Spena Erojikwe, thank you for your kind words. And thank you for holding the fort, because before we started, I was joking and asking, how did we get over 4,000 people registered? And hoping that all of you come on board. We already have almost 700 people within the first 5 minutes. That's very impressive. And it shows the good work that your team is doing, Mr. Chairman. So it's a privilege to be part of this, as the tradition to give back at the bar. We're looking at intellectual property rights. And my main focus will be, as the chairman said, the intellectual property strategy and policy, emerging legislations, which kind of a little slightly different from what I was told, but I mean, it makes I even prefer that. So I hope we have a wonderful time this afternoon. I hope you can all see my slides. Okay. So I want to welcome colleagues from all parts of Nigeria, and maybe some people who may be linked up from outside Nigeria. I want to thank the president of the NBA for maintaining the culture of continuity. A good team, a winning team, ought not necessarily to be changed. And it's good to see processes and patterns moving in the bar seamlessly. I want to thank him. He's probably the tallest, or at least the tallest son. I always joke with him about his gown. So this afternoon, I'll be blazing the trail, opening the door for a number of colleagues who will be taking us over the next couple of days. And the question we had asked is how to pitch this, because some people are new, completely new to IP. Some others have some training or practice exposure to IP. And yet we want to be able to meet everybody and be able to highlight significant developments. And so it's a big task, and I hope that we'll be able to do this. Fortunately, we also have times for questions and answers. And so please, I believe that you should be able to send in your questions, and the chairman, moderator, will be able to call on you or read the questions later. So this afternoon, I intend to give an outline of what intellectual property rights are. intellectual property laws in Nigeria, I intend to highlight the pervasive role and impact that intellectual property has had in the last few years. It's just increasing. In fact, in 1945, Zechariah Chaff, writing in Columbia Law Review, did say that copyright is Cinderella of the law. Those of us who read or seen the movie, read the story of Cinderella or seen the movie, we know that Cinderella was hidden in the back quarters, but she came to play a more prominent role. And that's what intellectual property is doing in the leading law firms in the world. Intellectual property departments are playing key roles and earning very, very substantial revenue. So what is the situation in Nigeria? We'll be looking at the IP strategy and policy. Recently, Nigeria, for the first time, has a working paper, which is intellectual property strategy and policy. There have been many attempts in the past, but another attempt started about 2020 and culminated in recommendations which have been passed on to Mr. President, which we're expecting that the Federal Executive Council will sign. Now, one of my mentors is late now, Stephen Stewart, who was one of those that negotiated one of the significant intellectual property conventions, the Rome Convention, said to me about 30 years ago that often there's a difference between the law on the streets and the law on the books. So a law may be passed, but how does the law become effective? How does the law become enforced? How does the law become impactful? We all, as law students, know that one of the attributes of law or descriptions of law would be that law is an instrument of social engineering, an instrument of social change. And the question is, how can intellectual property bring about social change, social engineering? Perhaps why has it not done so? How can it do so? How can the NBA, how can the bar ensure that this happens? So we'll look at the possible impact of the IP policy and strategy, what the plans are, perhaps the roles. You may be able to identify the roles you can play. Then I had put here that we'll be looking at geographical indications of origin, but as the chairman who is directing this said, it is more of emerging legislation. So I hope I'll remember that to maybe say some more about emerging legislation, what is expected, like the franchise bill, like the bills on geographical indications, and so on and so forth, and recently passed laws. So I have a working definition here for intellectual property. And it is that there are the regimes of law that seek to protect creativity, inventiveness, brands, and those that create, those that oil the engine of inventiveness, and those that use brands to market advantage. And intellectual property grants some persons transferable property type rights. Property is what most of us are used to, land. So the types of rights that intellectual property grants are very similar to land. But essentially, some people say they are negative rights. I don't always agree, but it means that they are rights that can be used to stop third parties from copying, using their creativity, inventions, and brands without their permission. And that's the focus of our discussions over the next couple of days. Now, intellectual property regimes has several rubrics. You have copyright, you have trademarks, you have designs, you have patents, you have plant variety, you have animal variety, you have confidential information or trade secrets. Some people say these are sister rights or allied rights, the law of privacy, and traditional knowledge. Some of these rights are rights that inure, you can only get them after registration. Some of these rights, you do not need a form of registration, like land. You know, you can be the owner of your land without having a registration. Okay, so there's some of those rights that you can own and exercise without any form of registration. There are some that you cannot have unless you have a registration. Now, for those that, if you don't have a registration, I mean that the law requires that you must have registration, you discover that they are within national boundaries, in the sense that just like you have a register in Nigeria of lands, or in the States, you also have register for some of those rights in Nigeria. And if you want to have similar rights in other parts of the world, you may have to register such rights in the other countries. Now, let's start with copyright. Copyright is a kind of right that can vest without registration. It protects and deals with literary works. That includes books, letters, software, poems, artistic works, drawings, sculptures, photographs, paintings, maps, musical works, music, sound recordings, the recordings of sounds, whether recording of music or recording of music and other things. Films, cinematograph films according to the law, which has now been changed to the new, under the new law to audiovisual works, and then broadcasts. Now, the copyright is governed by a new law. You know, I did say the chairman mentioned that there are new and emerging laws. So there's a new law that was signed by Mr. President about 17th of March, I believe. It was passed by the National Assembly late last year. It arose from the work of the Copyright Commission. Old Copyright Act 1988 as amended. And then Senator Abiru introduced a private members bill to the National Assembly. I think it was 2021. And the efforts of the Federal Executive Council with the Copyright Commission and the Senator Abiru's bill were harmonized together, and this became the Copyright Act 2022. An interesting point in that, as a teacher, just throwing this in the air, the National Assembly passed it in October, was signed in March. Should it be Copyright Act 2022 or Copyright Act 2023? Maybe somebody will respond to that later. But you notice from my slide that I put no R there. That means you do not need to register for copyright to vest. So you take a photograph, you draw someone, even though your drawing is not the best. You write a poem. Once you are a Nigerian or a citizen of Nigeria or somebody resident in Nigeria, that makes you a qualified person, and your work therefore becomes eligible for copyright protection once it is fixed in a form from which it can be reproduced. So if you write a poem, of course, it's already fixed, you can photocopy it. If you draw, you already fix it in a form that it can be reproduced. So music, if you record it, it's also in a fixed form. And so that's what copyright protects. And copyright vests initially in the person who creates it, the author. Later on, I'll be highlighting the fact that sometimes an author may not own the copyright because he has signed an agreement to transfer the copyright to a third party, maybe his employer or somebody who commissioned him. So the right you have as a copyright owner is the right to stop third parties from dealing with your work, like reproducing it or translating it or using it in another medium, or changing it from, adapting it from one genre to another. For instance, it's possible to write a play for stage, and then somebody makes it into a film. So the right to do that, the right to translate, Chimamanda's books have been translated into several languages, Sipranekwensi's books into over 30 languages. Those rights are bundles of rights that belong to the copyright owner. And you can stop third parties from dealing with it. They must take your permission before they deal with those rights, those works. Now, trademarks. Trademarks protects things like names, logos, brands, get-up of products. And in Nigeria, the law that governs trademark is the Trademarks Act 1965. You also have some other laws, like I mentioned there, the Merchandise Marks Act. You have Counterfeit and Fake Drugs Act. A number of laws also deal with marks. But what are trademarks? They are marks that are applied to products or services that distinguish them from other people's products or services. And so, for instance, if you go to you want to buy toothpaste, you go to a shop, a store, and you distinguish one type of toothpaste from the other. If you don't have toothpaste, if you don't have trademarks, what we'll be doing will be to feel or taste like we do with Gary or we do with granules. When we go to the markets and they are not properly branded, we identify them through the people who sell oh yes, that woman that whenever she's selling, this is the song she sings. I want to buy from her. So trademarks help us to distinguish products and services. And trademarks is governed by the Trademarks Act 1965. And this suggests that the law is old and may not be meeting up with some of the demands of today. So recently, for instance, Mr. President signed the Business Facilitation Act 2022, which, among other things, made certain amendments to the Trademarks Act. Trademarks give the owner of the mark the right to stop third parties from copying the mark, from applying the mark on their own products or services. And trademark deals not just with the mark in its form, as in its identical form, but if there is a similar mark that is confusing or can confuse consumers, the owner of a trademark may be able to stop you from using those. The test for whether a mark is confusingly similar or identical is what is called oral test, the sound, or visual, the look. Because the way a logo, for instance, the logo of the Bar Association looks may be different from the sound of the mark that's associated with it. And the test is not a test of placing it side by side to say, oh, this is the logo of the Bar Association, this is the logo of this other organization. But the test is a vague recollection. That is, oh, I have seen it before. Does it look alike or sound alike? Let me give you a couple of examples. A mark. RALEIGH was the biggest brand for bicycles when I was young. And it was fashionable to have a rally chopper, a rally this or that. Now it's spelled RALEIGH and pronounced rally. But if you put another word, RALLY, near the rally for bicycles, it may not look alike, but it does sound alike because the pronunciation is similar. And so the person who has rally for his bicycle may be able to stop another person from using RALLY for his own bicycle, his own products. Now, trademark is registrable at the Trademarks Registry in Abuja, Ministry of Trade, but it is also possible to have protection for your products, the brands, even if you do not have a registration. I would advise that you should have a registration because it gives the advantage that all you need to do is to produce your mark, your certificate, or extract from the certificate, the journal, the register, sorry, of trademarks. Meanwhile, if you do not have a registration, the only way you can stop somebody, for instance, let's say Raleigh did not register their RALEIGA's mark in Nigeria. And a Nigerian entrepreneur wants to use RALLY for his bicycles. Raleigh, the foreign company, may be able to establish that they have been producing, they have been selling their products in Nigeria, and people have come to associate those products with their bicycles in Nigeria. And so under the common law action of passing off, they will be able to stop the Nigerian entity from registering RALLY. Now, designs are design law in Nigeria protect new shapes. So the shape of the packaging of your product, of your perfume, of your beverage or drink, the design of your textiles, the designs of electrical circuits, the design of parts of products, of the spokes of tires or rim of cars and things like that. Any kind of products of that nature that before they are produced industrially, they are first of all drawn. And it is that drawing that is then reproduced maybe with a mold or a pattern, and the pattern is produced industrially. Such drawings, such products are registrable as industrial designs in Nigeria under the Patents and Designs Act 1970. And as you can see there, there's an R. That means that there is no right that inures to you unless you have a registration. This is critical because Blisco, one of the leading brands in terms of textiles in Nigeria, was not able to pursue a case some years back because it was trying to rely on the law of copyright in the drawings, but the drawings are such that they are registrable, and because they are registrable, they needed to, and they were not registered, they could not pursue their rights. So we need to note this so that we can advise our clients of the sandals or shoes, things like that. The designs of plastic chairs. You notice that plastic chairs are basically the same, a seat and maybe a backrest, but some of them look finer than the others. So all those designs are registrable as design rights. And that's at the Patents and Designs Registry in Abuja, also Ministry of Trade. Now, patents protect inventions. The inventions may be improvement on other people's inventions. The inventions may be something which is completely new that has never been thought about or produced. And that is protected by the Patents and Designs Act 1970. And you can see an R there, which also suggests that without registering your invention, there is no protection. So a professor from Obafemi Awolowo University, which used to be University of Ife in those days, invented the yam pounding machine. The professor did not register his invention, and soon we started importing yam pounding machines from Korea or from Japan. The professor would not be able to have rights to restrain the other people who are now producing the yam pounding machine. Now, in many parts of the world, people who breed plants or breed animals and they are able to breed a species of the plants or the animal that is stable and uniform, such that when that plant is, that particular plant will give back, will produce another of its type, and it will be uniform in its characteristics. The same thing for animals. In some parts of the world, they have what is called plant variety rights or animal variety rights. In Nigeria, we have the Plant Variety Protection Act of 2021. So we can see that in the last few years, there have been quite a few laws. The Copyright Act 2022, the Plant Variety Protection Act 2021. We never had any form of plant variety protection in Nigeria. The best we had was that those who were able to breed plants or seeds had a form of registration. But if you recall from my working definition of intellectual property rights, it's to give you a right to stop third parties from copying your creativity, your invention. So before 2021, those people who were able to develop new species of plants and seeds could not stop third parties from copying them. But with the Plant Variety Protection Act, if they register, you can see an R there. Because if you don't register, there is no protection. So lawyers can make money by advising clients and helping them to effect registration. Just like you register a company, you register land. There is work. Now, we also have another species of rights called confidential information, trade secrets. From the nomenclature, from that name, confidential information, it means information that is shared in confidence. In Nigeria, there are lots of people that share information in confidence with people that they want to finance or maybe go into joint venture with. Oh, I have this program, I have this idea, and they share it. And the people they share it will say, oh, I'm not interested, or it is not good enough. And a few months or a year or so down the line, you find out that these ideas are being exploited and they are making money from it. The law that protects that in Nigeria is the law of confidential information. So information shared in confidence, it has its common law, its roots in common law. But then you also have the law of privacy, which has its roots also in common law and also in the Constitution that protects fundamental rights, Section 37, to privacy. So, for instance, if I take your photograph, the 1988 Act, Copyright Act says I am the author of the photograph, therefore I am the owner of copyright in the photograph. And like I've said, the owners of copyright have a right to stop others from reproducing, so reproducing the photograph. But I have a right to reproduce it myself. However, can I use your photograph and place it as an advert, place it on the internet, and use it to promote my products, or just use it in an advert? That would be a breach of privacy. And that is a common law right, and also, like I said, constitutional. There's no form of registration, and so that without registration, you can sue. And the good news, distinguished, should I say gentlemen, because it's MBA, is that some of them for well over 100 years. enormous damages have been awarded, up to 16 billion for patents, up to 5 billion for
It appears that we've lost Prof for a moment. We do apologize for that technical hitch. We expect to have him back shortly. Okay, Prof is back. Prof, thank you. We lost you for a moment.
Okay. Oh, I see. Oh.
Wale, can you help put up the
Hello?
slides again? Wale, are you there? Are you able to help get the slides up again? Prof, we can see you now anyway, and I'm sure we can hear you. And
Hi,
I'm putting up the slides.
Yeah. Yeah. Can
No
you?
problem.
Can you hear me?
We can hear you now.
Me?
It's better. Yes, we can hear you now, and your slides are back up. Thank you.
Okay. Okay. Sorry about that. So
your camera appears to be off, Prof.
Yeah. So traditional knowledge is the last set of rights. Can you hear me?
We can hear you, but we can't see you.
Can you hear me?
We can hear you, but we can't see you.
Okay, you want to see me and hear me. All right. All right. Can I continue now? Good.
Please.
So traditional knowledge protects folklore, protects knowledge that I can say is passed from generation to generation. And we have a lot of that all over Africa and some other traditional societies. And some of us have been pushing, there are a lot of African scholars that have been pushing that this form of rights should be protected as intellectual property rights. So for instance, the chewing stick, a particular kind of, it's not every tree or stem that we use for chewing stick. What we fail to do in Nigeria, in many parts of Africa, is to investigate what exactly is in that chewing stick that makes, cleans and protects the teeth. Now, Oyinbos will come over and they identify that traditional practice, traditional knowledge that we use a particular stick, and they will investigate what the active ingredient or compound is. They will produce it and they'll be selling it to us. They'll get a patent on it. And we are saying, no, we must have systems of protecting this and maybe even stop some of us are even saying we must be able to stop an invention based on my father's knowledge that I shared with you. At least if you're going to get such a patent, my father or my community should be able to benefit from it. But to instruments, but international instruments. And so we are still a long way from doing this, particularly because we need to be able to identify, is this from my region or your region? Then who owns it? So there's a number of issues with it, but I can't concentrate on that. I can't delve into those details now. And then I did say that we have the Business Facilitation Act 2022 and the Nigerian Startup Act 2022. I'm going to make some reference to the Startup Act and also be highlighting the Business Facilitation Act in terms of what it has done later on. It's freezing. I don't know whether it's from me or from you. Okay, right. So what is the impact of intellectual property? What's the impact of creativity, inventions? Let's use our smartphone as a case study. All smartphones have trademarks, their name. Some of us have smartphones that we are very proud of. We show off with it because the brand is Apple, iPhone. Some of us have some brands that we don't want people to see it. But they're all logos that
Prof, we're struggling with hearing you again.
That are registrable as trademarks. Now, on this same smartphone, so many apps run on
Prof, you're frozen. We can hear you. Prof, we lost you for a moment there and we didn't hear you for a while.
Yeah, I was trying to change my provider.
Okay.
Yeah, trying to change my provider. So now what I should do is get back my my screen to be shared.
Yeah, thank you.
Okay. Can you see my screen now?
Yes, we can.
Oh, good. Right. So yes. So the inventions, or apps that run on our smartphones, some of them are patented. That means they are registered. Otherwise, you can't say they are patented. On our smartphone, we have a lot of content. If it's music, if it's videos, if it's art, if it's films, if it's broadcast, all these are protected by copyright. On our smartphones, we have a lot of data. Our financial transactions. These are protected by copyright, by confidential information, by law of privacy. Some of the smartphones have very interesting designs for their keyboard or some other things. And those new designs are registrable as industrial designs. Remember my definition? Because before producing the smartphone, somebody draws these designs. Those kind of designs that are reproduced industrially are registrable as industrial designs. And then all those logos, all the brands of the apps, they are also registrable as trademarks. So intellectual property deals with the extent to which third parties can exploit all those rights we've spoken about, I've mentioned, without the permission. Like I said, IP is like real property. It means that it can be licensed, it can be assigned, just like real property. It can also be used as security. The PAMA has some interesting provisions that support the use of intellectual property as collateral. Some of us are pushing that this need to be strengthened so that, for instance, somebody's invention and patent, somebody's repertoire of music or books may be used. Chinua Achebe of Fela's family can use his music as security for loans because the music is still being exploited and licensed. So intellectual property owners have exclusive rights. You stop third parties from dealing with your rights. You are the only one that can deal with the rights. Most intellectual property only lasts for a period. So patents will last for 20 years and it's renewable annually. If you fail to renew, it falls into, it lapses and anybody can use it. Designs last for 15 years. That is 5-year terms, 3 5-year terms. You register it now, you renew in 5 years, you renew in 5 years, and after 15 years, it lapses. So even for those textiles or the shape of the bottles, beverages, when Guinness, Star, when they were having issues with people counterfeiting their products some years back, they decided that because everybody was using the same bottle, they should change theirs and use it to distinguish themselves in the marketplace. And they registered new designs, new bottles. But those bottles will no longer be protected after 15 years because that's a maximum period. For copyright, you can have up to 70 years plus the life of the author. That is the year Fela died plus 70 years. The year Cyprian Quincy died plus 70 years. The year Shakespeare died plus 70 years. After that, anybody can make use of your rights. And trademarks are renewable at the end of each term for another term, and trademarks can be renewed forever, unlike patents and copyrights and designs. Like I said earlier on, the creator often will be the one to have the rights. The inventor often will be the one to have the right. But if he could by law, the rights could be transferred to the employer or the person who commissioned him. So there's a very interesting distinction I'd like to place here for patents in Nigeria as against copyright. So if it is something that is registrable as a patent and you invent it the employee, once it is done in the course of his employment, that is the kind of thing you are hired for. You are not hired as a cleaner and then you invent a chemical that is used for drugs. But you are hired in that team, and in the course of your employment, you invent it. The right to get the patent belongs to the employer. There's a difference with copyright because the right belongs to the employee. And so it's important to check that out. Now, a main focus today is the intellectual property policy and strategy. Policies guide folks in terms of limitations and methodology. They help to identify goals and objectives. In my university, for instance, Babcock, we joke that our vice chancellor is Mr. Policy. If anything happens, he says, oh, what is the policy on that? And so you go and look at the policy documents for guidance. And if there is no policy on the issue, then a decision may be made without that guidance. But if there's a policy, our vice chancellor says, no, 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 I want to follow the policy. So a strategy may be what you could call initiative to pursue, to achieve the goal. Now, you must have a strategy, I would say, is a foundation for success, because you cannot be pursuing a goal without having a strategy. And I'd like to just say this now. It's very important for our intellectual property, but for us as lawyers generally, that lawyers, law firms, law departments and corporations, and individuals must have policies and strategies to achieve their goals. What kind of lawyer do you want to be? What kind of law firm do you want to be? What kind of department do you want to be in the next year or 3 years? You identify the goals. You need to have a strategy. How do you get there? You cannot develop a strategy without identifying the goals, without doing a baseline a situational analysis or a SWOT test. And the SWOT test on intellectual property, on the creative and innovative system. SWOT, by the way, as most of us know, is acronym for strengths, weaknesses, opportunities, and threats, SWOT. So we need to do that also for our organizations. And that is what the Nigerian government did recently for intellectual property. And I want to say that the NBA must also do the same for and have an intellectual property strategy or policy for lawyers. What will this entail? How can lawyers become big players and earners in the IP media technology space? Lots of money is being made in media. More money is going to be made. Lot of money in the technology space. And the question is, are lawyers ready? This exercise, and I thank Trobena and the president for this, is one strategy in equipping lawyers for this, because you need to know the law. And then the question will be the clients and how to get the work in and so on. So we need to ask ourselves questions. Are we being consulted by relevant stakeholders? So for instance, Flutterware and so many startups in that sector in Nigeria, are they using lawyers? Are they protecting their IP? Are the lawyers earning? The film industry, media industry has blossomed in the last few years. Can we analyze how much has come to lawyers? Just like the local content law for oil and gas. mandates that we should find out how much is spent for lawyers, on Nigerian lawyers and service providers in that sector, which I don't think we are really doing. But this is a challenge to the NBA. We need to find out how much, and as we develop our capacity. Now, the work on this policy began, I think, 2020, and it was a collaborative effort between the federal government of Nigeria. Kudos to the Copyright Commission, the Ministry of Trade, Trademarks Registry, Patents and Designs Registry, and they worked with all the other regulators in the IP space, the Plant Variety Office, and the process was in two phases. In 2020 to 2021, there was a preparation of an inception report. A lot of people were consulted all over the nation in various sectors, and an IP audit was done, and he examined the state of the IP system in Nigeria, focusing on the interface between the use of IP system and the economic development of the country through innovation and creativity. The exercise also examined the existing law, the framework, issues of enforcement, the structures relating to IP, and various policies of the federal government relating to things that pertain to IP were also examined. And all these things were brought out, and a SWOT analysis was done. And the second phase, which started January 2022, entailed collaboration and then presentation of the initial reports and bouncing this off a number of stakeholders, which I think culminated in an exercise about June of last year, and this was presented to the federal government. So that is, for the first time, we now have an IP strategy and policy. Previously, the government had done some. There was an effort by NOTAP, but they did not involve or carry along all the other stakeholders. But this one, everyone was consulted, and we are hoping that it will work. Because like I said, like Stephen Stewart, we have laws, but it doesn't mean the laws are working. Why are the laws not working? Why is there not a higher level of inventions in Nigeria? And if we have higher level of inventions, are the inventions being taken to the marketplace? Because all some of us need is to be the lawyers to one big invention that becomes Microsoft, and we are made. So those are some of the issues which we'll be talking about this afternoon. This thing is season again, I hope. Okay. Right. I hope you can still hear me. So this table is extracted from the document that's been submitted to the government, the National IP Policy and Strategy. The vision is to make utilize intellectual property for sustainable national prosperity. It's no point having the law and the law is not impacting. It's not an instrument of social change or social engineering. The mission is to promote a comprehensive and conducive IP ecosystem, to act as a catalyst to harness the full potentials of IP for development and sustainable economic growth in Nigeria. And so what are the objectives? One, to strengthen legal framework to protect IP. To strengthen institutional framework, because one, the law may be good, but the institutions administering the law may be weak. For instance, is the Copyright Commission well properly funded to do its work? The Trademark Registry, the Patents and Designs Registry, for a while have not been able to issue certificates because of lack of funding from some weaknesses that arise from institutional framework. So this will frustrate entrepreneurs. It will frustrate the goals that people have to make IP achieve a sustainable economic growth. So the third is to enhance the generation and protection of IP. That is, we want more IP to be generated. How do you ensure that, for instance, universities are producing inventions? Are universities doing research that is relevant, for instance? Is there anybody doing a master's or a PhD in trying to extract the active ingredients in that chewing stick? Or like Nema University, the sponge that we use, traditional sponge, is still the same method of production. It scratches and itches the skin. It breaks and blocks drains. Why can't we improve the method? Why can't we improve its sustainability so that it doesn't break and so on, doesn't affect the skin? My father used to like in fact, today would have been his 95th birthday. He died 25 years ago. Now, he used to like black soap, that traditional black soap. Now, somebody improved on that black soap and is selling it as Dudu Osun. Now, what can we do to further improve on it? When I was young, my grandma used to use, they call it adiagbon, which is the groundnut oil. But I didn't like the smell. But if you put it on, during Harmattan or anything, your body will be shining, your hair will be lustered. Now the question, why haven't we improved on that over the years? So to promote and facilitate commercialization of IP, exploitation of IP, so that it's not enough that somebody invents, but how do we ensure we take it to the marketplace? How do we strengthen the legal and institutional framework? How do we develop human resources for the administration? How do we promote IP training, education, and awareness? Those are the objectives. Those are the objectives. And you can see here, we have short-term, medium-term, and long-term plans. So short-term, for instance, review the patents, the legislations. And like I said, there's some that have been reviewed, the copyright one. Develop new ones for geographical indications of origin, for instance, utility models, possibly trade secrets. Develop regulations. So we have a Plant Variety Act 2021, but no regulations have been passed. How can you work without regulations? We've signed quite a number of treaties, but we have not domesticated them. So we are saying this thing should be done. We should establish the Industrial Property Commission. Now, some of you may not know that in 1988, we had the Ministry of Trade housing the Copyright Office, the Companies Registry, Patents Registry and Designs Registry, Trademarks Registry, all of them were warehoused as a commercial law department of the Ministry of Trade. Copyright, we fought, should be brought out, and a copyright commission was made in 88. In 1990, Justice Orojo and the others, Law Reform Commission, fought to bring the company's registry out, and it became CAC. Since 91, we have been fighting to make Trademarks Registry, Patents and Designs Registry into a commission. So that, for instance, this excuse that you can't get a certificate will no longer be there. We lobbied, and the government, I think under President Obasanjo, agreed that 20% of whatever they generated will be kept by them. But I'm not sure that is still happening. That is what the NBA should be doing. Various intellectual property organizations, that's what we should be doing, so that we will not be frustrated. So that it won't be that it's those who know people have their certificates issued. Now, introduce examination system, improve the examination system, develop automation of the registration system, develop a operational system for the plant variety office. So the plant variety office is like a small department in another organization, I think Seeds Council. And because we feel that it should either be on its own, or it should be part of maybe an industrial property commission. But because it's just a small department, it may not be able to develop the way it's supposed to develop. And these things are very, very critical. So enhance and foster industry linkage, promote recognition of intellectual property for promotion of researchers. This one is a medium-term thing, but I want to say that it's already been achieved, in the sense that in the universities, if you have a patent, it can be used. In some universities, they say it's equal to about 4 papers. So if you publish your paper and you don't obtain a patent, that publication may make your work no longer new, and therefore you cannot obtain a patent. So if you obtain a patent, you can use it for promotion. So the National Universities Commission has bought into this. Now we say support more university and research institutions to establish IP policies and revise existing policies. The National Universities Commission has worked on this, and there's a draft IP policy that all university vice chancellors have bought into. And so many universities now have IP policies. But I know also that even when they have the policies, sometimes they don't implement the policies, because that's why implementation, strategy is also important. How do you ensure that these policies are being implemented? Use of patents for information, for patent system, information system for research and innovation. If you take a patent is supposed to have in its documentation what is called a specification. The specification should describe how to work the invention. So ordinarily, those are very useful tools, but many are not exposed to this. So we need to teach people how to do this. We need to strengthen linkages between universities and industries. Universities don't talk to industries. They don't know what industry needs are. And so they produce graduates who may not really meet the needs of the industry. The research being conducted in most universities may not meet the needs in the university of industry. So this is part of the strategy to make IP work. So through fairs, through exhibitions, and so on and so forth. Capacity building for professionals. NBA is doing this very well, but we need to do even more. We need to develop commercialization of IP framework. So for instance, if I have, it's not just in the university, you see people on the streets with very interesting inventions. How can we support this system and have an innovation system that brings this thing to the marketplace? We say that NOTAP, that's Office of Technology and Acquisition, and other government agencies should be, their capacity should be improved so that they may be able to help to link people. The other day, I was with one of the agencies, and the number of inventions they had supported innovation. However, those inventions had not gone to the marketplace. So develop and implement a plan for the commercialization of traditional knowledge and traditional medicine. Like I said earlier on, the chewing stick, or somebody goes to farm or goes to the farm and is bitten by a snake, and people say, oh, use this leaf, rub it and tie it, and because you use that leaf, the venom in the snake comes out of your blood, oozes out of your blood. What is in that leaf is traditional knowledge. This is our own traditional medicine. How do you ensure these traditional medicines are approved by NAFDAC and can be used? So it's not just importation of these things from China. You know, how do we promote technology transfer in the universities? Many universities have technology transfer offices now, but our research, one of my PhD scholars, now an associate professor in University of Olabisi Onabanjo University, very interesting work she did. We discovered that many of the universities, yeah, there's a lot of work going on. However, their technology transfer offices do not even know about it. Even though there's a university policy that they should know and be involved. So we need to drive these things. Otherwise, the law on the streets, the law on the books, sorry, will remain on the books and will not be actualized in the streets. We need to develop and promote technical research in university. We need to ensure that financing for the creative sectors, for the innovation sectors, develop collecting societies and management systems such that it's not just making money for the individuals who run it, but making money for the owners of the rights and using that to develop the ecosystem. Towards this, one of the laws that's been passed, and I commend this administration, is the National Nigerian Startups Act 2022. That act established a National Council for Digital Innovation and Entrepreneurship. One of the things that we should realize is that if there's any aspect of technology that Africans or Nigerians can catch up with the rest of the world and be world leaders, it's in this sector, digital innovation. And so Section 31 of that act identifies the importance of intellectual property. I have it there, but because of time, I won't, you go and read, you know, that they must encourage and collaborate with the stakeholders, the regulators, to ensure that there is registration and there is exploitation of the intellectual property rights. There's protection and so on and so forth. Commercialization. In fact, this law was what some of us used in the presidency recently to say, Mr. President, you've signed this Startup Act. The Startup Act says intellectual property is important. In your campaign in 2015, you said you would do something to intellectual property. You cannot leave as your position as Mr. President without signing the copyright bill, which has been passed, because this, your Startup Act, says that intellectual property is important. And I think that was well received, and Mr. President signed about a month ago the Copyright Act. Now, the Business Facilitation Act also makes a number of amendments to the copyright statutes. Intellectual property statutes. For the patents, it introduces a scheme for compulsory licenses for the minister to be able to, when you have, for instance, during Ebola or during COVID, assuming that the world did not come to our aid by making these drugs available free, and the drugs were available at on affordable prices, maybe $10 or $100, and most people cannot afford it. But then some may be imported from China or produced locally, maybe by even my university, Babcock University. It can be produced there, and for a fraction, the minister may grant what is called a compulsory license. Yeah, a compulsory license simply means a license that is compulsory. All the other licenses should be voluntary. So you are forced to give this license, although you'll be paid some money. So that is a scheme introduced by the the Business Facilitation Act for patents. The Business Facilitation Act also introduces under the Trademarks, amend the Trademarks Act to expand the definition of trademarks and goods to include services. Although this may create some problems because there was already a regulation that sought to do this. That regulation we knew was not the best, but it was a compromise that some pushed so that at least we will have registration for services. For instance, lawyers don't sell goods, we sell services. So the name of your law firm can be registered as a service mark. So the new Business Facilitation Act validates this, but it may also open some of the other earlier registered ones to questions. That doesn't mean it was not valid before. That's for question time, not for me. Or maybe it's my exam question to you. The Business Facilitation Act also expands the definition of goods marks in such a way that you can now register shapes of products. I said that the packaging bottles, for instance, can be registered as industrial designs, but after 15 years, that lapses. But if you want to continue to use it, you may be able to use a trademark, a registration. So because Nigeria has signed up to a number of international treaties, particularly under the World Trade Organization that's been headed by our sister, the aspect of it relating to intellectual property named TRIPS is enjoins us to make a lot of amendments to our laws. And so there are bills before the National Assembly on franchising. There are bills before the National Assembly on trademarks, on setting up an industrial property commission to take over the trademark and patents registry. And it behoves us to work towards pushing these bills into law. Now, just checking the time. Let me just say a few things about geographical indications of origin. This is a form of, arguably a form of mark that can be used to differentiate products. So recently, the example I gave there, recently, I saw some products, Ijebu Garri, produced in Ghana, in China. Or maybe they are now importing Ashoke from China. They are importing Ofada rice from China. They are importing Nsuka from China. Would you like this? Should we not be able to stop this? Geographical indications are this kind of products, usually for agricultural products, cultural related products, and things like that, but which help us to identify and say, oh, this product is actually from this part of the world or this part of the country, and it has this kind of characteristics. Now, the fact that you grow your own rice to be similar to the one grown in this part of the world, in this part of Nigeria, does not mean you should call your rice Ofada rice. Does not mean you should call your Garri Ijebu Garri. So we need to have a species of trademark protection such that we can stop the rest of the world from copying us. And those are what you can call geographical indications of origin, because they indicate the origin of the product with those characteristics. And the idea is to vest the people who produce them with rights to stop other people from producing them. You can't stop them from producing something similar, but they shouldn't use those names that make that help them in the marketplace in terms of branding them. So some people feel that the Trademarks Act, Section 43, which I produced there, because it mentions something about characteristics of products and so on, that the origin of product may help certification marks. Certification marks are marks that certify, for instance, if you look at some well-sewn suits, you'll see a label there that says wool. So this is real wool, okay? So it's prepared this way, it's made from this, so it is certified, okay? But we are saying that this is not just certified, but it's from a particular place. So we need a special law. The question for us is, should this law be part of the Trademarks Act and administered by the Trademarks Registry? Or should it be, just like we have the Plant Variety Act and Plant Variety Registry, should we have a Geographical Indications Registry and a Geographical Indications Law, which is not necessarily part of other laws? Debate is still going on. And I think because of time, I would want to stop here and give opportunity to address some of these things better during question time. Tobina, I hope I've managed the time well.
You've managed the time brilliantly, and excellent presentation. I would speak at the end of the session, but I would like to, I don't know whether any of the panelists would like to comment on your presentation before we go to question time. I know that Mr. Femi Agaba is here. Mr. Agaba, do you have any comments? Okay. Ms. Ebike, do you have anything to say?
So listening to Prof's comments, Prof's presentation actually just reminded me the reason why we do what we do. We love what we do, as intellectual property practitioners. So we're at the back end helping clients to actually protect these marks. So hearing all of what Prof has said, it gives us hope that, when we encounter the problems in the practice areas, we know that there are solutions that are actually in the pipeline to actually sort all of these problems. So Prof, thank you so much.
My pleasure.
Thank you. Well, Simi, I reckon you can make your comments and then take question time. Then at the end of the session, I'll make my comments and say thank you.
Mr. Chairman, before they start to make their comments or questions, I will send you the slide so that you can share it, because people are already asking. Sorry, I didn't share it earlier.
No, thank you very much, Prof. Thank you. Thank you. Grateful. Okay, Simi, over to you. Question time.
Thank you very much, Prof, for the detailed presentation. Like Ms. Ekiben said, it just took me way back to my early days in practice, reading about this, and thank you for breaking it down like we're actually in the classroom. A lot of things I even have more clarity on a lot of things. Thank you very much, sir. So the first question, we have a lot of questions here, so we'd like to take as many as we can. The first question here is about passing off and copyright infringement. So the question is, what is the difference between passing off and copyright infringement? Hi, Prof. Can you hear me?
Oh yes, I can hear you. Yes. I can hear you. So, passing off can be very wide. It's like I said, a trademark which is not registered. You may be able to use passing off to stop somebody from from copying the trademark. But you must establish that your mark has developed goodwill, let's say local goodwill. People know it here, which you don't need to do if you have a registered mark. Now, copyright infringement deals with literary works, artistic works, musical works, sound recordings, now audiovisual works, and broadcasts, as against trademark passing off that deals with trademarks. Now, the interface could be, I remember some years back, I think it was with Cadbury, there was a very interesting scenario where they had not registered a mark. It was for a new confectionery they were going to introduce in Nigeria. They had not registered the mark in Nigeria. A Nigerian company was producing, was about to hit the market with similar products. Now, the drawing of the product, of the logo, was what we used as an artistic work to stop the product from entering the market. So essentially, the point is, copyright deals with stopping somebody from using your work without your permission. Passing off deals with using your get-up, your logo, so that nobody can use a confusingly similar one or an identical one without your permission. So that I would say is the distinction between the two.
Thank you very much, Prof, for answering the question. And the second question is, I understand that some countries allows for the registration of copyrights and design side by side. For an industrial design, that's registration of both copyrights and design, while others don't. What is the scope of the registration in Nigeria?
Yes, the law has just changed in the last 1 month for copyright. I did say designs. There's no, if something is registrable as a design and you don't register it, then there's no protection, because designs like patents are some rights that you can only have upon registration. Now, some countries allow registration of copyrights, like America, and the current copyright, the new Copyright Act, also has a more robust regime for registration. However, the same act also provides that there is no formality for copyright protection. So once you have created your work, it's like the copyright is a right in the air that just clutches it and protects it. Okay, but if you do register, there may be some advantages you would have. One of the advantages is, for instance, proof. So you can prove, for instance, that, oh, this song, I composed it in 2015 and I registered it with the Copyright Commission. And so somebody comes up with a song in 2020 and you can say, oh, I already had this with the Copyright Commission, and you have come up with this. So that can help you in terms of proof. So if the interesting thing for copyright, though, is that because most countries belong to one of the international conventions known as the Berne Convention, which say essentially says there must be no formality to copyright protection. No country can make registration a prerequisite or compulsory, but countries may make registration of your copyright an advantage. So for instance, in America, if you register, you may be able to sue for attorney's fees, which if you don't have a registered copyright, you cannot sue for attorney's fees. So there is that advantage. And then there's also the presumption that goes with their registration that it belongs to you. So it's the other side that has to come and establish that, no, it does not belong to you because you already have a registration.
Thank you, Prof. The next question here is on yam pounding machine as an example. So the question now is, using the yam pounding machine example, if the Nigerian professor had registered his rights in Nigeria, will that registration restrict the foreign company in Japan from deploying the technology to Nigeria if the technology is original to the foreign company in their places of registration?
Yes, if the registration was already, you have a Nigerian patent, the Japanese or Korean or any other person cannot import or manufacture the yam pounding machine in Nigeria. You cannot manufacture it here, you cannot import it, you cannot sell it in Nigeria. That is the kind of right that the patent gives. It restrains third parties. But if you have only a Nigerian registration, you don't have a Ghanaian registration, then they may take it to Ghana and sell in Ghana, and you may lose the Ghanaian market as a result of that. So the registration systems, you need to do country by country registrations, or I'm sure Mr. Gaba and all the other, including the moderator, will be speaking on other registration systems outside Nigeria that you may be able to use to protect your rights beyond Nigeria. By the way, can I have the email to send the slides to, so that I can do it right now? Please go ahead with questions, ma'am.
Okay. The fourth question here is, please, what if a customer paid a photographer to take the pictures? Can a photographer still claim ownership of the work paid for? Also, in a case where a photographer took a picture of a person without the consent of the said person, can the photographer claim to own ownership of the photo?
Yes, I did say that under the Copyright Act, and there's a slight change under the new one, the 1988 one, which is part of laws of the Federation. The position was that the photographer is the author and therefore is the owner of copyright. So even if you paid him, he's still the owner of copyright. And that's why if you want to use the work, ordinarily what we advised under the old law was that you should have a contract with him, giving you a license. However, because of that difficulty, so for instance, we are having this MBA function, and assuming it was live, the photographer takes photographs, we pay him to take photographs, and we want to use it for to publicize some MBA programs, or even this program in future. You cannot reproduce it you could not reproduce it without his permission. But because of that difficulty that we saw under the copyright or old law, the current law, the new law, allows you to have a license to be able to reproduce without his permission in limited circumstances. Okay. Now, if the person takes your photograph without his permission, without your permission, he's still the creator of the work. So he has a right. But the copyright he has does not mean he can use that work for an advert. That will be breaching your privacy, and you can sue him for breach of privacy under the Constitution and under common law rights. So the fact that you are paid is not enough. Copyright, it is best that you have a contract, a clause in the contract of employment or contract of commissioning that the right vests in you rather than in the person who did the work.
Thank you, Prof. The next question: what can you say about the protection of business method under the umbrella of patents at the Patent Registry?
Sorry, I didn't get that.
What can you say about the protection of business methods under the umbrella of patents at the Patent Registry?
I can't give a one answer fits all. However, the way patents laws are structured all over the world, you have a part of it, the law that identifies some inventions that are not patentable. Then you have a part of the law that says these particular ones are not inventions for the purposes of the act. Now, in many laws, let me just say many laws, in some laws, business methods are mentioned as not being patentable. And that is why many people in Nigeria have argued that, oh, they are not patentable in Nigeria. In fact, there was a case which is still kind of, a portion of it is still on, but the main part which the other side pushed and urged the court to set aside, nullify our client's patents. The court did not agree. It was a software invention, and the argument was software inventions are not patentable. So this debate has been on, but the court did not agree. And the question for me will be that we have a Startups Act, which is for digital, which is, you know, why and it recognizes IP. Why does the government want to say no to this kind of things? You know, it's a policy thing. It's something which we need to look at. So do we say no to an area where we have a market advantage, or we say no? Yes, because we need to protect this and make the thing grow. So it will depend on when you say just business methods per se, or business methods that does something, because business methods per se may not be patentable. But like I said, I can't give one. We need to really analyze it. And sometimes what we do is then tell the clients, oh, why don't you go further and do this, so that at least you'll be able to surmount any test of obviousness or anything.
Thank you, sir. The next question here is, you talked about breach of privacy using an illustration of a photographer using the picture of a customer for branding or adverts. Does that breach apply?
Yes, I mean, we've had several cases ourselves.
Uses the bank's logo for its program adverts.
Yes, so we, like I said, we've had quite a number of cases on this. They take your photograph and then they now use it and associate it with the logo or with the product of their clients. The advertising company or the company itself does that. If they want to use your photograph in such a manner, they need your permission. Otherwise, they will be breaching your privacy.
Thank you, sir. The next question. Prof mentioned that an employee has the right to patent an employee, and an employer has the right to patent an employee's invention. Will the employee have some benefits accruing from the patents?
Yeah, very interesting question. Very important too, because one of my mentors, Jeremy Phillips, in '73, that was the subject matter of his PhD in Cambridge. Now, it's so important to the innovation system and part of what we've been discussing, that since what we have adopted in Nigeria is that an employee who invents something because of his employment, that is a kind of thing he was employed to do, the right to obtain the patent for the invention, over the invention, belongs to the employer. Our law, the Patents and Designs Act, 1970, prescribes a system where the employee will be entitled to something over and above his salary if under two sets of conditions. You know, if the invention, the patent is important, and the kind of revenue, for instance, the company makes from the invention is significant, then he will be entitled to a reasonable sum. If they don't want to pay, the court will have to determine that. And what we may need to do going forward is to improve the system so that the court will have a way to calculate this and to assist so that matters will settle quickly because there is some guidance. Because it's not easy for an employee to sue his employer or former employer on such things. So it's good that we push for regulations that give some further guidance. But the entitlement of the employee, according to the Patents Act, is not modifiable by contract. So you cannot say, by way of, excuse me, in your terms of contract, to say contract of employment that you cannot be and you will not be entitled. No, our law says you will still be entitled. That's a good thing about the law, our law.
Thank you, Prof. The next question says, after several attempts, it seems becoming an accredited IP agent is an equivalent tax. Please kindly advise how to be accredited.
Oh, that should not be difficult. We can put you in touch with the patents and designs registrar or the trademarks registrar so that they would be able to guide you on this. There's some monies to be paid and so on. In future, there may be an accrediting system, and that's the goal, that maybe we should have a way to streamline patents or trademark agents or attorneys like it's done in some countries. But at the moment, you apply and pay what is due, and you'll be granted accreditation.
Thank you, sir. AI is now reproducing music that mimics great songs, artwork of notable artists, etc. Please, what is your take on how to protect the rights of creators?
If you have a song, if anybody, including AI, takes a substantial part of that song in a way that it can be recognized to have been derived from your song, they'll be liable to infringement. So you can sue. The question for AI will be, who are you suing? Are you suing the AI, the owner of the AI, or the creator of the AI? And so those are questions which the lawyers will need to determine on a case-by-case basis. But very interesting, some friends of mine, 8 News Square in England, just about a month ago, also obtained some of these cases there was one on patents and AI. The invention was made by AI, and the person who created the AI said, no, I created the AI, but I was not, it was the AI itself that created, that invented. And the court said, well, the law only recognizes individuals, human beings, not machines. So you cannot apply for a patent for AI. That would be very interesting in Nigeria.
Yes, very. So the next question here is, how do you think Nigerian governments can protect the public from fake products or unoriginal products?
Well, I think the government is trying, but they need to do more. So for instance, the NAFDAC, National Office of Food and Drug Administration Control, and Standards Organization of Nigeria, SON, the customs, they have been very instrumental in administrative procedures in stopping, and also, sorry, FCCPC, that's a Federal Consumer Protection and Competition Commission. They have been very instrumental in seizing fake products, counterfeit products, and prosecuting them, those who distribute them. So the federal government is trying. They need to fund those agencies more. But then those are also private rights for the trademark owners, for the copyright owners to also pursue those who have infringed, and not just leave everything to the government.
Thank you, sir. The next question says, you talked about breach of privacy using an illustration of a photographer using the picture of a customer for branding or adverts. Does that breach applies where a company approaches the bank for sponsorship? I think we've taken this question. The person asked again. So we'll move to the next one. What is the rationale behind software enjoying copyright protection in the light of the fact that the software could sometimes be an invention?
Interesting question, but I'm not sure I can explain in 5 minutes. The Berne Convention, one of the protocols amendments introduced and mentioned software specifically for as a literary work, and I think that is what's it called? That is the source of the Nigerian law also saying that, mentioning specifically that software is a literary work, because part of it in terms of the code is literary. You know, you are 00s, 999, not, ... all that language is like a written work. So that is what gave birth to it being treated as a literary work. Now, a lot of software will not amount to inventions that are patentable. And as such, if we say it's only patents that can protect them, then people may be able to copy them. So that is why there is copyright protection, but then there's also patent protection for some kind of software. Some software enjoy only copyright protection, will not enjoy patents because they are not patentable.
The next question is, can a phone application be registered as a patent?
A phone
application?
You know, on the phone, there's a lot that can be done. You have an invention, for instance, on your phone that can you place in your house, and somebody gets to your house and you can shut the door, you can know who it is, and so on and so forth. So some of these things are inventions. They are not obvious. And so they meet the test for obviousness. They meet the test for novelty. And they are industrially applicable. Therefore, they should be patentable. So some applications are patentable, even though they are driven on the phone, driven on computers or machines, and so on. So it's difficult to just say, oh, these things are not patentable, because the National Assembly has not mentioned them as one of the listed things that are not patentable, unlike maybe the Indian or part of the even European Patent Convention that mentioned some things, you know, maybe a computer program per se those are not listed in Nigeria.
Thank you, Prof. The next question, if a student invents something while taking an engineering class in a university, who is entitled to such IP? Is it the university who granted a provisional admission to the student and employed the lecturer, or the lecturer sharing traditional knowledge despite being an employee, or the student?
Very brilliant question. It's my typical exam question. Now, I did say that part of this national IP policy is to urge universities to have IP policies. And I did say that the National Universities Commission, the Committee of Vice Chancellors, now have a model IP policy. So the idea is that each university will have an IP policy. The IP policy will deal with this issue. And oftentimes, any invention by the student will be, the right to obtain the patent will be the university. However, the student under the law, and maybe his lecturer, or maybe the student alone, if he didn't have any lecturer supervising him, will have to have his name listed as what is called the true inventor on the Patent Act, on the patent itself, the patent application, and when it is granted. Now, in terms of remuneration, what may be shared in my university, for instance, I'm trying to recall, I think there's a policy under our policy, a formula, sorry, under our policy that the university will take maybe 30%, the faculty will take maybe 70%, between the faculty and the students and the lecturer, they also share it, and the department. So it's a fair policy in terms of distribution. The idea is you want to encourage invention and innovation, the innovation system, and you cannot do it without encouraging the particular faculty or department or teachers and maybe the student, if the student is involved.
Thank you, Prof. The next question is, what is the difference between trademarks and certification marks?
Okay. A certification mark is a form of trademark, but it goes further than a trademark in the sense that it certifies that that product was made, or maybe even the goods, in line. For instance, the MBA seal is a form of certification that the person who used the seal is certified by the bar to be a lawyer, you know. So no other person can use that seal except the people who have gone through the process of certification. So that is the simplest way I can distinguish between a certification mark and an ordinary mark. Like I said, some suits, lawyers, you'll see a logo and says wool. So that certifies that this material is wool, is not this or is not that, is not fake, and so on. So nobody can use those marks except those people who are produced in line with those rules, and not just anybody. You know, members of the established who have gone through the training and who use that methodology in producing the goods or the services who use certification marks.
Prof, one last question here. We have a lot and it is not possible for us to take everything. So please,
and I see that Tomina is back to knock.
He's back.
Yeah, I actually have a proposal. We've screenshot the questions and propose to answer the ones that we cannot take today, and then include it in the materials that we circulate at the end of the training. So Simi, go ahead.
You stated that designs are registered and renewed for 15 years. Please, what happens after 15 years? Do they need to make another design?
After 15 years, there's no protection again. So, for instance, Handel Messiah song, Hallelujah, Hallelujah. and they'll die since. So anybody can make use of it after it has expired. So any intellectual property that has a period, once the period is over, you could say it falls into public domain in the sense that members of the public, third parties can use it. The purpose of IP is that the right owner can stop third parties. That right extinguishes, so anybody can make use of it after the period. So the best thing, like I said, will be that after 15 years, the Guinness bottle, the Star bottle, all those newly registered bottles registered some 15 years ago, if they don't want people to copy them, they must have new designs. Otherwise, people will start producing those bottles and maybe copying them and reduce their market advantage.
Thank you very much, Prof. Thank you for answering all of the questions today. Thank you.
And thank you for moderating the questions and removing the difficult ones.
Thank you very much.
Simi, thanks a lot for anchoring question time.
You're
Prof, what an amazing delivery, what an amazing presentation. I mean, when we put together these kind of trainings, this is exactly what we want to experience. And I must say it has been an experience, because I think all in one put together, you've managed to let us know that everything in the creative space, from innovation to technology to the arts to entertainment to everything that is quite current and modern, especially amongst Nigerians, are things that have rights and they can be protected. And indeed that we can grow that space and have more people involved in it, because you can't actually do something that you don't know about. And so it's been very, very illuminating today. You've taken us through new legislation. You've taken us through emerging legislation. You've actually also mentored us on how to live life, set goals, do different things. So it's an all-encompassing lecture, and I don't think we could have wished for anything better. I mean, the comments on the chat box attest to how satisfied and happy that our participants have been. And I must say to everybody that's listening, it takes time to prepare for these trainings, both for the faculty and the individual lecturer. And it also takes time. It's been 2 hours of Prof's time today, and he's given off of the knowledge that he has, and he's spent a lot of time acquiring. And we must be grateful to him, and be grateful to the faculty for the great work that they have done in trying to carry everybody along. I think one of the greatest things that we expect from our association, or one of the greatest things that any professional body must pay attention to, is the training of would-be members and the consistent and continuing training of those who are in the profession. Because if we don't focus on these areas, then our profession will die or go extinct. So, Prof, thank you for your leadership. Thank you for all that you do for the IP space, for the legal profession in Nigeria. We're grateful to you. We will continue again tomorrow. Another very distinguished practitioner, Mr. Femi Agaba, will be taking a session on IP due diligence, which is also very contemporary at the moment. So thank you very much. And I hope to see everybody again tomorrow. Do please pay attention. Between now and March next year, we have training sessions lined up throughout. And I think that, and I must commend the IP faculty, because they were actually the first faculty to deliver a training for the MBA ICLE during the Akpata regime. And they've kicked it off again this year, and we're happy for the support that they give to the Institute. Thank you very much, and God bless you all. See you tomorrow.
Thanks for having a great institute. My pleasure. Bye, everyone.
Thank you, Prof.
Right.
Tomorrow then. And you'll get the slides and the recordings are at MBA.
If I have your email, I can send it to you.
Yeah, Prof, I've sent it on the WhatsApp group.
Okay.
I've sent my email on the WhatsApp group, yes.
I'll do it in the next 5 minutes.
And just to let everybody know that there is a YouTube channel called the MBA HQ. Anybody can go in there and see all the trainings. You can see the IP training that we had in 2021, and all the other trainings. I think we have about 60 something of them sessions out there that you can just go in and log in and view. So thank you very much, and God bless you all.